says from, okay. I just wanted to check because I always forget about
it. Alberto. Oops. Thanks for pointing it out.
No worries at all. Like, it happens to me all the time. So I just wanted to make sure whether that was deliberate or. But yeah, thank you so much once again, Ben, for your very kind introduction. And I would like to thank more generally the whole organizing team of AHSN 2023, as well as congratulating all of you for putting together such an impressive and exciting program. It's really an honor for me to be here next to so many amazing speakers, and I very much look forward to attending as many panels as possible despite the time differences indeed. So I will jump right in by sharing my PowerPoint in a second. You should be able to see it now. Does it work? Yeah, that's perfect. Okay, so as you can guess from the title of my talk today will focus on the intersection between humor and the law, with particular regard to the ways in which courts of law interpret humorous material in cases regarding free speech and the limits of free speech. Hopefully this will, of course, resonate in many ways with the overarching topic of the conference, a human right to humor. We'll definitely be talking about human rights a lot today. By focusing on humor and the law, it is important to say that I am building on a growing body of scholarship on the topic, started with the volume Judges, Judging and Humor, that was edited by Jessica Milner-Davis, who is great to see here, and Sharon Roach-Allo in 2018, as well as the book Guilty Pleasures, Comedy and Law in America was published by Laura Little in 2019. But in addition to that, I would also like to mention the work of João Paulo Capellotti on humor in Brazilian case law, and more recently, the special issue of the journal Humour, titled Humor and the Law, the difficulty of judging jest, which Ben also mentioned during his introduction, and which I had the pleasure of co-editing in 2022 together with Brigitte Adriansen, Ted LaRose, and Andrew Bricker. So all of these examples point to the growing academic interest in the relationship between humor and the law, which is also due, of course, to the increased relevance and visibility of debates regarding the limits of humor in the digital age, or some argue in the post-digital age, an age in which potentially offensive or harmful material can circulate very fast, well beyond the original context, thus leading to what Linde Kuipers already back in 2011 defined as transnational humor scandals. A recent example of the relevance of humor and the law in today's mediascape is the widely covered amicus brief that was submitted to the US Supreme Court by the satirical magazine The Onion. You might remember that from a few months ago. It was in support of a resident of Parma, Ohio, in the US, who had been prosecuted over a Facebook parody page mocking the webpage of the local police department. But the list of examples could go on and on, including, for instance, the interpretive conflicts sparked by British comedian Jimmy Carr over a controversial Holocaust joke, which became viral on YouTube last year. Or just to give another example, by the ongoing debates on the ethical and legal limits of deepfake comedy. So in a nutshell, this is the type of material that I am also dealing with in my own research. Speaking of which, in particular, what I am going to discuss today is based on the work that we are carrying out as part of a project that I am coordinating, which is called Humour in Court, and is funded by the Dutch Research Council from 2022 to 2027. So it's a 5-year project. The Humour in Court team consists of myself as well as 2 legal experts, Jennifer Young and Matteo Fiori, and a PhD student with a humanities background, Melissa Leipars. So in short, the starting point of our project is the observation that courts of law often have an inconsistent approach to the interpretive issues posed by humor, namely the fact that the same given joke, cartoon, or meme can usually be interpreted in many different ways by different audiences. In this sense, we argue that insights coming from linguistic, literary, and semiotic research on humor can be particularly useful precisely because those approaches mostly focus on the textual and contextual factors determining the interpretation of a given humorous text or expression. In other words, these types of humanities research can provide courses with a shared toolkit, hopefully, and a systematic vocabulary to deal with humor, especially with the subjectivity of the interpretation of humor. So with this in mind, the key questions behind our work are the following. First of all, what are the interpretive criteria or the tests used by courts when dealing with the interpretation of humor and satire in free speech cases? Secondly, what are the main problems or inconsistencies in the application of those criteria? And lastly, related to that, how can the court's approach be made more consistent and fairer, hopefully in light of insights from humanities-based humor research? In order to tackle these questions, we are now analyzing a corpus of approximately 400 humor-related cases from the European Court of Human Rights, mainly, and national courts in the United Kingdom, France, and the Netherlands. So this is the immediate scope of our project, but we do hope that some or most of our findings will also contribute to improving the approach to humor in courts of law beyond this immediate focus area. As part of the project, among other things, we are also working, in fact, on this searchable database of legal cases on humor and free speech from all over the world. This is still very much a work in progress. On our website, you can currently find around 170 cases, but we will keep expanding the database in the coming months and years. By the way, the website where database is stored is called Forum, as Ben also pointed out and wrote in the chat, Forum for Humor and the Law. You can find it at www.forum.org. And it's a platform that I recently created with Laura Little, catering for lawyers, legal and humor scholars, cartoonists, comedians, and anybody really who might be interested in the intersection of humor and free speech and related legal issues, clearly. If you are interested in finding out more about this, as well as general news from the world of humor and the law, you're very welcome, of course, to email us or sign up for the newsletter via the website. Okay, so at this point, I will just dive into my actual presentation, which consists of 3 sections. First of all, I will give a quick introduction to existing human rights-based approaches to freedom of expression, and then briefly mention the challenges posed by humor in this context. Secondly, I will zoom in on one specific case from the European Court of Human Rights, namely ZBM France, which is, I would say, a telling example of the interpretive challenges created by humor in court, and also an example of how courts could benefit from a closer dialogue with humor research. Lastly, I will point to a few pending issues highlighted by recent humor-related jurisprudence, which call for further cross-disciplinary work at the intersection of humor and the law in the future. So to start with part 1, when it comes to human rights approaches to free speech, a good starting point is Article 19 of the International Covenant on Civil and Political Rights, which is ratified by 173 countries worldwide. So this is as comprehensive as it gets with regard to human rights provisions on free speech. Article 19 has 3 parts, as you can see. First of all, everyone shall have the right to hold opinions without interference. Secondly, everyone shall have the right to freedom of expression, regardless of frontiers, either orally, in writing, or in print, in the form of art, or through any other media of their choice. And thirdly, the exercise of the rights provided for in paragraph 2 of this article carries with it special duties and responsibilities. It may therefore be subject to certain restrictions, for the respect of rights or reputation of others, for the protection of national security or of public order, or of public health or morals. Now, this may sound relatively clear in theory, but in practice, it can actually be quite difficult, of course, to draw a clear line between lawful and unlawful speech based on these provisions. I will now turn to the European Court of Human Rights as a case study, only because that's the main focus of my research. However, many of the points we will stress here are also, or can also apply and do apply to human rights systems outside of Europe as well. Now, in the jurisprudence of the European Court of Human Rights, as well as of other human rights systems, the line between lawful and unlawful humor, and lawful and unlawful speech in general tends to be drawn based on an indicative distinction between offense and harm. In other words, disputed speech tends to be protected when it is deemed to merely cause offense on a subjective level, while it tends to be restricted when it is considered to also objectively harm somebody's status in society, as is the case with defamation or with incitement to hatred, discrimination, or violence, for instance. Also, importantly, the European Court of Human Rights, as well as other similar and comparable human rights systems, emphasize that public figures, such as politicians, should display a higher level of tolerance towards ridicule and satire. Now, this seems like a rather solid, objective rule of thumb, and it is in fact used in an overall convincing and consistent way by the European Court of Human Rights in several cases regarding humor too. For example, in VBK in Austria from 2007, and in Dickinson in Turkey, the court sided with the authors of satirical works which were considered as offensive but legitimate criticism of public figures, namely an Austrian politician in the first case, in the former case, and Turkey's President Erdogan in the latter case. On the other hand, in cases like Ferré in Belgium and Le Pen in France, the court ruled against jokes that were found to be not only offensive, but also harmful to vulnerable minorities in Belgium and in France, respectively. That being said, there are also cases where the outcome or the reasoning behind it is less convincing, perhaps, or less consistent, and the court could have benefited, in my view, from a closer dialogue with humor research. So at this point, I will actually zoom in on one of those cases, in my view, and which is also the main case that I would like to discuss today, namely ZB and France, which was adjudicated by the European Court of Human Rights in December 2021. So I will start with a quick summary of the case first. The case focuses on a rather distasteful joke printed on a t-shirt, which the applicant, ZB, gave as a gift to his 3-year-old nephew in September 2012. The t-shirt bore the words, I am a bomb, je suis une bombe, on one side. We are in France, by the way, of course, near Avignon. This is also important to know the context clearly. So the t-shirt read on one side, I am a bomb, and on the other side, Jihad, born on 9/11. The child is actually called Jihad, which is a rather common name in the Arab world, and was indeed born on September 11, 2009. Crucially, the term bomb can also mean good looking in French. So that's the idiomatic meaning of the expression here. The t-shirt was then worn only once at preschool by the child, and was only seen by adults when the preschool's director and one of the employees helped Jihad change his clothing in the bathroom. In the domestic proceedings, the applicant and his sister, so Jihad's mother, were charged with the criminal offense of glorification of terrorism. The applicant, ZB, received a 2-month suspended prison sentence and a €4,000 fine. while Jihad's mother, so ZB's sister, received a 1-month suspended prison sentence and a 2,000 euro fine. The case went all the way to the European Court of Human Rights, which unanimously upheld the domestic ruling, meaning that they essentially confirmed the interpretation that was put forward on a national level by the Nîmes Court of Appeal, which we can read here in part. Certain attributes of the child, his first name, day and month of birth, and the use of the term bomb, which cannot reasonably be claimed to refer to the beauty of the child, in reality serve as a pretext to valorize unequivocally willful attacks on life. So to start with, the idea that the t-shirt unequivocally glorifies the 9/11 attacks is, I would say, far from indisputable, as proved by the fact that the first instance court had reached the opposite conclusion, but we will get to that in a second. For now, I would like to start by reflecting on the Court of Appeal's statement that the French term bomb cannot reasonably be claimed to refer to the beauty of the child, because this is, I would say, clearly flawed from a rhetorical perspective. I am a bomb is in fact a rather conventional metaphor where the source domain bomb is equated or is projected onto the target domain child based on a perceived analogy which is well established in the French language. Therefore, technically, the word bomb does refer to the beauty of the child, and more generally, the t-shirt's allusions to the 9/11 attacks are part of a rhetorical construction where terrorism is being primarily evoked as the source domain, ultimately referring to the child through metaphor, while of course also playing with the coincidence whereby a child named Jihad was born on 9/11. So as awkward or distasteful as this might be, this type of incongruous metaphors is typical of humorous communication, as humor scholars know very well. In this sense, the ZB joke is actually quite different from the cartoon at the center of another famous 9/11 case from the European Court of Human Rights, namely Leroy in France, which was adjudicated in 2008. In a nutshell, the Leroy case is about this cartoon, which was published by the applicant on a French Basque magazine in September 2001, only 2 days after the attacks, actually. In the cartoon, we can see a drawing of the Twin Towers attack with the dubious caption, "We had all dreamed of it. Hamas, for some reason, did it," which is a parody of a Sony commercial at the time. The applicant back then said that his intention was not to disparage the victims of the 9/11 attacks, but rather to highlight double standards in the media representation of bombings and attacks in the US, as opposed to those happening in the Middle East at the time. However, the French courts convicted Leroy of apology for terrorism, and the European Court of Human Rights unanimously confirmed that decision. Now, regardless of the details and what we might think of this Leroy case, at least in this case, the cartoon was indeed about the 9/11 attacks, while the ZB joke mostly uses 9/11 as the source domain of a metaphor, ultimately referring to the child. Notably, the ZB judgment explicitly mentions Leroy as a similar case and as a significant precedent. However, a closer engagement with the rhetorical functioning of the joke could have allowed the court to also highlight the important differences between these two cases. And in this sense, I would say a stronger familiarity with humor research could probably help courts provide a more nuanced interpretation of this type of jokes. In addition to that, my impression is that a more direct engagement with humor studies could have improved the ZB decision, not only with regard to the textual and rhetorical aspect, but also when it comes to dealing with context in a systematic way. In particular, in my view, there are 3 contextual aspects that are not paid sufficient attention in the ZB ruling, and that humor scholars could help shed some light on. First of all, there is what Vili Tsakona in her 2020 book calls the specific communication setting, namely the specific space and time in which a joke is produced and circulated. As ascertained by the first instance court of Avignon in France in the national proceedings, the child only wore the t-shirt on one occasion, which was limited in time, the afternoon of 25 September 2012, and space, the nursery class. And only two adults had been able to see the words on the t-shirt while dressing the child. So, of course, a class of 3-year-old children is far from constituting an inflammable audience on a political level, one prone to being radicalized by a dubious joke on a t-shirt. And as to the preschool director and the teacher, so the two adults who saw the t-shirt, they might well have been shocked by the joke, but they could hardly have been turned into jihadists, which is the scenario evoked by the criminal charge of glorification of terrorism. This was duly noted by the first instance court of Avignon, but later neglected by the Court of Appeal and the European Court of Human Rights, which is rather striking in my view. So this was the first contextual aspect. A second context-related aspect worth mentioning is what literary theorist Lisbeth Cortaz-Altes defines it as a prior ethos of the author or speaker, namely the image of the speaker, or at least the image that we can have or reconstruct of the speaker on the basis of their reputation, previous deeds, or generally known character traits. So the relevance of prior ethos to humor interpretation is something that has indeed been acknowledged by the European Court of Human Rights in other cases, although with a different terminology. Nevertheless, in the ZB decision, the court states the fact that the applicant has no ties with any terrorist movement whatsoever or has not subscribed to a terrorist ideology cannot attenuate the scope of the disputed message. Now, this is also striking, I would argue, as one could say that the speaker's ideological ethos does seem relevant when it comes to criminal charges like the glorification of terrorism, even more so when the disputed text is a rather ambiguous joke in and of itself. Lastly, the third contextual level that I would like to stress is genre. So the discursive tradition, we can say, to which the joke arguably belongs or can be ascribed to based on its dialogue with, or its perceived dialogue with a given set of conventions. In this sense, I think that the ZB joke should be seen in dialogue with a genre of humor often used by comedians from a Muslim background post 9/11, which is based often on the Islamophobic, on the ironic use of Islamophobic tropes, such as, for example, all Muslims are terrorists. Shortly after 9/11, for example, British stand-up comedian Shazia Mirza famously opened her set with the line, "My name is Shazia Mirza," or at least that's what it says on my pilot's license, which rather than being meant as a glorification or trivialization of terrorism, was meant as a sarcastic critique of mounting Islamophobia after the attacks. Similarly, the contested t-shirt in the ZB case can also be seen as an attempt, however awkward, to make fun of the Islamophobic cliché casting Muslims as jihadists until proven otherwise, let alone a family where a child is named Jihad, which is actually a common name in the Arab world, as I said, and does not come with any inherent fundamentalist connotations. Somewhat ironically, if that's the case, that is not too far from what actually happened, as the outcome of the case shows precisely that it is quite difficult for a Muslim family to engage in dark, distasteful humor on 9/11 without being accused of actually spreading jihadism, which is, of course, something different from dark, distasteful humor. In this sense, I find it particularly enlightening to compare ZB with a case from the High Court of England and Wales, namely Chambers and Director of Public Prosecutions from 2013. So this latter case is about a man who was due to travel within a couple of weeks from the Robin Hood Airport near Sheffield in England which was closed due to adverse weather conditions. So since his journey plans were jeopardized by the airport closure, Paul Chambers here posted the following message on Twitter. Crap, Robin Hood Airport is closed. You've got a week and a bit to get your shit together, otherwise I am blowing the airport sky high. 5 days later, the airport security manager reported it to the police, and Mr. Chambers was initially convicted for sending a public electronic message of a menacing character, quoting from the 2003 relevant law at the time, the Communications Act. However, upon second appeal, the High Court quashed the conviction based on the following reasons. The Crown Court was understandably concerned that this message was sent at a time when, as we all know, there is public concern about acts of terrorism and the continuing threat to the security of the country from possible further terrorist attacks. In any event, the more one reflects on it, the clearer it becomes that this message did not represent a terrorist threat, or indeed any form of threat. The language and punctuation are inconsistent with the writer intending it to be taken as a serious warning. It is difficult to imagine a serious threat in which warning of it is given to a large number of tweet followers in ample time for the threat to be reported and extinguished. In a similar way, one could argue that many signs point to the ZB joke not being meant as serious jihadist propaganda. For example, the fact that it is printed on a child's t-shirt in a clearly childish font, or that, as ascertained by the first instance court, it was not meant to reach a wide audience of adult readers. However, ZB was eventually convicted, even though the European Court acknowledged that the applicant had no ties with any terrorist movement whatsoever or had not subscribed to a terrorist ideology. So if we compare the outcome of ZB with that of Chambers, it is hard not to see some kind of double standard there, or at least a notable inconsistency in the court's respective approaches to terrorist-themed jokes. In a recent article I co-wrote with Jennifer Young and Matteo Fiori as part of our project, we tried to set the basis for a more consistent approach to dark humor, these types of dark humor in court, by proposing an indicative distinction between three basic modes or types of dark humor, or to phrase it better, three potential ways of interpreting a given occurrence of dark humor. First of all, disparaging or threatening dark humor, aiming to dehumanize, vilify, or threaten the face value targets of the joke. Secondly, taboo-breaking dark humor, where the perceived goal is not to disparage or threaten the target, but rather to play with a topic that is usually seen as taboo or incompatible with humor, as is often the case with disaster jokes, for instance. And thirdly, sarcastic dark humor, where the offensive component of the joke is actually used to mimic and denounce somebody else's offensive behavior. For instance, using Islamophobic tropes in an ironic way as a way to denounce Islamophobia. Now, in the Chambers case, the High Court clearly interpreted the joke as an example of distasteful but lawful taboo-breaking dark humor. In the ZB case, instead, it can be maintained that the courts were too quick in classifying the joke as an instance of threatening dark humor without even considering its possible taboo-breaking or sarcastic interpretations. In short, and I'm wrapping up this central part of my presentation, regardless of what one might think of the final outcome of the ZB decision, both the Court of Appeal and the European Court of Human Rights could have paid more attention towards the metaphoric nature of the joke, as well as to crucial contextual factors such as the communication setting, the prior ethos of the speaker, and the genre that the joke can be ascribed to. On both levels, so text and context, we can say input from humor research could help courts reach a more systematic and fairer treatment of humorous expression. And this is the type of interdisciplinary dialogue that we are trying to pursue in our Humor in Court project. And this is why, in my view, this can also be a promising avenue for further research at the intersection of humor and the law in the future. On a closing note, and speaking of avenues for future research, I would just like to single out two pending issues that are particularly frequent in humor-related cases and that might benefit from insights coming from various strands of humor studies. First of all, a recurring question that is far from being adequately answered, in my view, is what exactly is the harm in disparaging humor? Or in other words, provided that a contested joke is classified as disparaging, when exactly does disparagement humor translate into actual incitement to discrimination, hatred, or even violence? This is a question that emerged, for example, in a very recent case from the European Court of Human Rights, namely Telo de Abreu in Portugal from just a few months ago, 2022. In this case, the applicant had published a series of cartoons which used sexist tropes in their satirical depiction of the municipal council of the city of Elvas, and in particular of a female council member who was depicted as a sow, so as a female pig with sensual attributes evoking the sphere of prostitution, and was surrounded by, quoting, naked humanized pigs representing other members, male members of the administration. The European Court eventually ruled that the cartoons, however distasteful, should actually be deemed as protected speech, as they are ultimately a form of satire targeting public officials who should display a higher level of tolerance to satire and ridicule compared to ordinary people. However, in her concurring opinion, Judge Julia Motoc argued that although she agrees with the final outcome of the proceedings, the case does prompt us to reflect on the close link between what she calls symbolic violence and actual violence against women in politics in particular. The present case concerned the issue of the use of stereotypes in the representation of women in politics. The national courts have rightly identified the issue of violence against women in politics in its form of symbolic violence. So this line between symbolic violence on the one hand and incitement to hatred, discrimination, and actual physical violence on the other is at the center of many other cases touching upon sexist, racist, or ableist humor, including, for example, the infamous Ward and Quebec case from 2021 about a Canadian stand-up comedian who mocked a young disabled singer and eventually won the appeal. This, of course, also taps into broader juridical debates on the extent to which hate speech bans are effective or the extent to which they might actually be counterproductive, which is a long-standing discussion in legal scholarship, which we don't really have the time to delve into right now. But either way, my only tentative remark here from a humor studies perspective is that in order to reach more informed decisions on these types of expression, courts of law could clearly benefit from more empirical studies on the reception and potentially harmful effects of racist or sexist jokes, for example, or ableist jokes, along the lines of the humor special issue on the social consequences of disparagement humor, which was edited by Thomas Ford back in 2015. This is one of the most pressing questions in humor jurisprudence, I think, as well as an ideal area for further dialogue between lawyers on the one hand and humor scholars coming from psychology, sociology, and linguistics on the other. So that was one of the pending issues that I wanted to kind of foreground. The second and last pending issue that I wanted to mention today can be summarized with the question, who is the reasonable reader in the digital age? This question refers to the fact that when dealing with the different possible interpretations of a given joke, courts usually adopt the so-called reasonable reader test, namely that the author of a given joke or humorous expression may be convicted when the contested joke could be interpreted as harmful by a reasonable member of the public. However, the notion of the reasonable reader is, of course, always a fuzzy and quite problematic one, even more so In the digital age, where, as recently argued by Nick Holm, among others, the pervasiveness of deadpan humor and ironic ambiguity makes it particularly difficult to determine what exactly is the behavior and the level of contextual knowledge that we should expect from a hypothetical reasonable reader. An emblematic example, and the last case that was mentioned, that I will mention today in this respect, is Tilakawardana and OIA, which is an English case from 2015. This all started when a student, let's call him student A, shared online some private pictures of student B, which he had received by mistake. So now, as a way to defend his friend, student B, another student, who is the claimant, namely student C, who is a medical student, his name is Tilakawardana, of course, because that's the name of the case, posted this meme on student A's Facebook wall. So as a retaliation, let's say, featuring a scene from the film Taken, where Liam Neeson says, it's a famous scene, and he says, "I will look for you, I will find you, and I will kill you." The meme was accompanied by a private Facebook message stating, "I don't want to see you on a night out in Leicester or in the UK." 1 month later, student A reported, so the recipient of the meme reported the meme and message to the medical school, arguing that it constituted a death threat. The medical school eventually expelled student C and declared him unfit to practice medicine. Then, according to the High Court of England and Wales, this was actually a legitimate decision on the part of the university board, as in their view, it is abundantly clear that any reasonable recipient of the meme would have a real and justified fear that he would be subjected to violence. By so doing, the court basically interpreted the meme as if it was a literal death threat. However, it can be argued that to anyone familiar with how memes work, or with how this meme template in particular is normally used, it should be clear that this is actually an exaggerated, or at least it should be arguable that this is actually an exaggerated and non-serious way of conveying somebody's anger or frustration. In other words, as stated by Lim or Schiffman, memes tend to be based on a logic of ironic communication, a type of communication that veers from a definite commitment to one's uttered words, using language in a playful and non-obliging way. And it is hard to believe that the recipient of the meme, who was clearly active on social media, could lack this fundamental awareness of how memes work, so much so that he only reported it as a threat 1 month after receiving it. This is not to say that memes can never be used to convey actual incitement to violence, as is also shown by a growing body of studies on the use of memes by far-right extremists, for example. However, in this particular case, the court's idea of the reasonable reader seems to be quite detached from the specific features of certain types of online humor, which both the sender and the recipient were arguably quite familiar with. In this sense, too, it would be desirable to see a closer dialogue between courts of law on the one hand, and recent work on new genres of online humor on the other. This also ties in with my previous point on genre and context in the ZB case. So I think I will stop here. I've already talked too much. Probably there will be many other interesting examples to mention, but I hope that the cases I've discussed already illustrate how building bridges between humor studies and the law can be mutually beneficial. On the one hand, insights from humor studies can help judges develop a more methodical and fine-grained approach to the subjectivity of humor. On the other, reflecting on humor-related cases can inspire humor scholars to develop new theory-driven as well as empirical research on the interpretation of potentially harmful or disparaging humor, among other things. So from both perspectives, this bridge building work, and more generally, this kind of bridge building work can lead us to a deeper and more nuanced understanding of the human rights to humor, and more broadly of the complex interplay between humor and human rights at large. So I thank you very much for bearing with me, and I look forward to the discussion. Thank you.
Excellent. Many thanks. Just give it up for Alberto and an amazing keynote. And we go straight to the questions. We've got 30 minutes to talk. Let's get Alberto some water so you can talk a bit more then. We've got Jessica with a question in the chat, so everybody can have a look at it. Jessica, if you might unmute and maybe just give us the gist of the question, and then Alberto has a minute to just take it in and then answer, and then we can get going.
Alberto, do you want me to read the question out, or?
As you prefer, Jessica. I've just read the question, so I'm also, if you want, I'm also ready to.
Please go then. Yeah.
But I don't have much to say, though. I can do some expectation management there. But so, like, just to summarize the question, it is indeed about this special issue of the journal Humour about disparagement humor, no, that came out in 2015. And as Jessica pointed out, missing from most psychological studies about this is the question of the duration of any impact from exposure to disparagement humor. So indeed, this time-sensitive component, no? And so the question is whether I know of any more recent key studies which do allow for that issue of measuring impact over time, and I have to say I'm not. But it could be my own gap there in my knowledge of more empirically oriented studies on disparagement humor. But to my knowledge, I'm not aware of studies that really take this chronological or diachronic component more into account. But I think that special issue is indeed an excellent starting point for future research in that direction, perhaps, which is also from a legal perspective, I think it's very much needed, because that's really the core of the issue, the one that you pointed out. So how does it work with time, no? And increased exposure, yeah. And when do jokes turn into something more serious? And this is something that many also recent studies on humor on the far right, for example, engage with, but I have not seen this being treated in an empirical sense or systematically. Yeah.
Ben,
Thanks very much. So we've got, Jessica has another follow-up. All right, Jessica.
Could I follow up on that? I have a story which is, I don't mean to disparage Tom Ford, because I have great respect for him and his work. And as Alberto says, that SI, special issue of humour, is a good place to start. And it's not just the legal consequences, although there's a very interesting issue there. Sort of at what stage should judges actually have humour research drawn to their attention? So it's some time ago, but I listened to a presentation by Tom, who is a strongly ethical person in his own personal religious beliefs, as well as an excellent psychologist. And the presentation was on this question of if you administer a questionnaire to subjects about, say, their attitudes on racism or sexism, and you get that as a beginning measure, and then you show them racist or sexist jokes as is appropriate, and then you administer the questionnaire again, what you get is an uptick in the degree to which their prior views have been influenced by what they've shown. And the whole audience in this international conference session was, oh, this is very worrying. Oh, what are we going to do about this? And Willibald Ruch, the leading senior psychologist, Tom, stood up at the end of a lot of anxious discussion. He said, excuse me, but did you measure how long the impact lasted? And Tom replied, yeah, 10 minutes. That rather put the presentation in a different light.
Yeah.
And I think it's analogous to a lot of the training sessions that we all have to go through in universities these days. Do they really have an impact? They might, because we know, or we think we know, what people are looking for when they test us at the end as to what we think. But once we've done with that, we go back to who we were.
Yeah.
Yeah,
no, indeed.
So my question there really is not, thank you for saying that you're not aware of anything further. We've got a whole bunch of psychologists in the room, actually, which is lovely. We haven't had them for quite some time. It's lovely to see the Rawlings there and Bruce Findlay as well. And no doubt there are others that I'm not aware of. But one of the things that I wanted to ask you now as my follow-up after that intervention, sorry, Alberto, is doesn't this give us pause for thought about when, at what stage of research we should actually be saying to judges, this is research on humor, you should be reading?
Yeah, absolutely. These are both very important points. Regarding how long the impact lasts, I can only add that there are indeed similar debates also in the field of literary theory, literary studies, for example, when it comes to the impact of reading fiction on theory of mind and empathy. That is also one of the frequent points. How long does that last? The alleged positive impact of reading fiction on our theory of mind and empathy skills, for instance. And indeed, there is a similar problem, of course, when it comes to the impact on, of disparaging humor on, and yeah, indeed. So there's much work to do in that sense. As to the second question, this is also a very good point, and this also ties in with the difficulties of trying to build these bridges between humor research on the one hand and lawyers, legal professionals on the other, because it's already quite difficult to engage in this work of translation of our respective methodological and theoretical frameworks. That in order to be able to do so in an effective way, we need to have solid findings to discuss. And that's also why in our project, for the time being, we mostly take, let's say, a more theory-based approach rather than an empirical approach to the types of humor that we are focusing on, precisely because when it comes to empirical findings on the societal effects of humor, my impression is that there is still much work to do. So what we already have is, of course, very valuable, but at the same time, maybe not ready just yet to be translated into legal guidelines that can be implemented. So in this sense, my impression is that the type of insights that can already be used by courts of law comes more from the theoretical side of things rather than from empirical evidence. But this is absolutely not to say that empirical studies of humor don't have anything to add to this conversation. They actually do, and a lot. But I think in this specific sense, it's probably more of a work in progress, in my view. Yeah, but thank you. Yeah.
Thanks very much. Any other questions, comments, observations that you'd like to address to Alberto? You just raise your hand and we can get to you. Mark, I see your hand up. Over to you, Ben.
Thanks, Alberto, for a very interesting paper. I much appreciated it. I was just wondering if you've come across any cases that have court cases that have dealt with trolling, because this idea of trolling is basically, well, I'm only saying these things to get a reaction. And obviously there's the issue of, well, how far is that merely offensive, or is it also harmful, to go to the dichotomy that you were raising earlier?
Thank you. That's an excellent question too. So among the cases that we are dealing with in our corpus, so far I cannot think of cases engaging directly with trolling, but there are quite a few from the meta oversight board, which is also a very interesting source of cases, especially from the digital age, so to speak. And when it comes to the use of social media, there's, I think, a more interesting wealth and breadth of cases coming from the oversight board of Meta, where cases involving trolling can definitely be found. And most of those decisions indeed go back to the issue, when do jokes end up translating into action? And that's indeed, I think, one of the main open questions in the in this nascent field of research on humor and the law. So I cannot mention or summarize any of those cases specifically, like right now, because I think I might end up misquoting or not rendering an accurate summary of any of those, but you can definitely find them on the website of the oversight board of Meta, and you will see that trolling comes up quite a lot in some of those cases. Yeah, and which have to do with either memes posted on Facebook or jokes or supposedly humorous reactions to previous posts on social media, especially Facebook. So there's definitely a lot of material there, probably more from social media adjudication bodies than actual courts of law, which kind of makes sense, because that is now the first kind of level of content moderation that users end up having to deal with, as opposed to actual courts. Yeah.
And I assume that the courts generally would not be well supplied in understanding trolling.
I mean, I fully agree. I think there's a lot of work to do there, in the sense of adjusting the notion of the reasonable reader to the logic and dynamics of online humor, which is something that, as shown in my view by the Tilaka Wardana case as well, the one about the Liam Neeson meme, I would say, independently from what we might think of the outcome of the case, if we read the reasoning of the course, we can see that there is a bit of a lack of deepening of the logic of online humor, which are not really taken into consideration in the court's decision. So it is indeed important to work together in that sense, for lawyers and judges on the one hand, and media scholars, humor scholars on the other hand. Yeah.
You want to get a Gen Z judge, not one that is not familiar with memes. So he might let you, or she might let you off the hook then. Right.
Yeah,
just to move along with
it. That might help. Yeah.
Yeah. There's another question in the chat just to get to that. And Bryce was asking about, do you think the law is bowing to cultural sensitivities and pressures in coming down hard on the kind of jokes featured in your discussion?
Sorry, I will have to reread the question just to make sure I understand it correctly. Do you think that the law is bowing to cultural sensitivities and personal coming? Yeah, on the kind of. There's definitely an interesting kind of feedback loop, clearly, like between the legal realm and the cultural realm, broadly speaking. This is something that we were discussing, I remember, with Jessica too, last year at the Humor Studies Conference in Bertinoro. So what is the relationship exactly between the judiciary and this, what happens and changes in terms of cultural sensitivities? And it is impossible to detach the law from culture, clearly. But the law is also is embedded like within broader cultural transformations, clearly, as well as having the power to some extent to let's say, contribute to shaping them. So it's indeed a feedback loop, I would say. I think we can definitely see that in the jurisprudence of the European Court of Human Rights. If we read the concurring opinion of Judge Motos that I briefly mentioned about the Portuguese case, we can really see that there is an effort to tap into ongoing societal debates, for example, on hate speech, that is not, I think it also depends on the specific judicial context. I mean, in the case of the United States, for example, now there tends to be this kind of indicative opposition between, on the one hand, the United States approach to free speech, which is very much, First Amendment rules, and you should not regulate speech unless it really comes down to an immediate threat of violence, of physical violence, while I mean, for example, in the context of the European Court of Human Rights, there is a much stronger inclination to regulate hate speech. So we can already see that there is a difference there in the level of sensitivity to ongoing cultural debates. But absolutely, there is an element of mutual influence there, I would say. Yeah. And as I very briefly mentioned, this is very much an ongoing debate in legal scholarship too, like to what extent hate speech bans are desirable or effective, or are they counterproductive? There is, of course, on the one hand, there is the argument whereby the only answer to hate speech is more speech. On the other hand, one can argue that this only applies when the target of hate speech also has a platform and equal power to speak back. I recently listened to this talk, this lecture by Nigerian author Chimamanda Adichie on the BBC that tackled these topics, I think, in a very interesting and nuanced way. Yeah. But this is, of course, a much broader juridical debate that goes beyond the remit of humor studies specifically, I would say. Although I would say that humor scholars do have something interesting to say about that. Yeah.
Perfect. Do we have any other questions? Oh, no. Jessica, did you have your hand up there? Yeah, Jessica, over to you then.
I think I'd just like to add in, Alberto, you mentioned Gianpaolo Capellotti's work on Brazilian judges and how they define cases.
Yeah.
I do hope he gets his book translated out of Portuguese and into
I hope so too.
for us all to read. But in the meantime, I might draw people's attention. I'll put it into the chat room. There's a very nice chapter that Gianpaolo has in the book that Sharon Rochaglio and I co-edited. And it's very revealing, Bryce, on this issue about cultural values, because what he finds is that in many cases, several cases that he discusses of Brazilian judges judging humor, the male judges come down on the side of the complainant whose machismo has been injured by the fact that his wife or girlfriend has been traduced by a joke. And I think Gianpaolo feels that this is definitely a cultural influence on how humor is judged in Brazil. Thank you.
Fantastic. Any other questions, comments, observations? Please share them now. We've got a couple more minutes left. Alberto, as people are still kind of figuring out their questions around this fascinating topic, I was wondering, so where you were saying, this is about responsibility and does a meme translate into action? So my question would be, so if you got like a chatbot and you program it, insult people mercilessly, and you move online, so where does responsibility, liability there, lie? Like with the Microsoft fail one, that merciless insulted people, they had to shut it down after like 30 minutes because it was so nasty. And you can say there's an experimental thing, but is it, what is it really? And the other bit I was wondering about, so as you were saying, the joke translates into action. Isn't that already an action, that meme? I was wondering if you had any thoughts on that. Like you show intent or what, the legal definition would be.
Absolutely. Like starting from your latter point, I think you're absolutely right. And there's, a growing body of studies considering the topic of hate speech from a pragmatic perspective. So hate speech as a speech act. So the line between words or images on the one hand and actions on the other is, of course, very fuzzy, and that's also, and this kind of gray area is precisely what makes this topic so hard to tackle, and also so interesting from a scholarly perspective, I would say. Yeah. Regarding the chatbot suggestion, this also sounds very interesting, and I'm very much looking forward to attending the Humour and AI session on Wednesday, right? Or at least the hybrid or online bits, and I'm looking forward to hearing more about that too. Yeah.
Now it'd be interesting. What is, what they're doing about an android insulting you? What's happening then? Or you give her arms and she slaps you across the face if you insult her. Interesting to see how far we can push this. Any other questions? Alberto,
I just wanted to say that, following up on the comment by Rodney about the reporting the meme a month later can be seen as an example of trolling or perhaps a nuisance claim. That's also a very interesting comment, I would say. And that's also something that came up in the proceedings. In this whole case, the position of the recipient of the meme is very unclear, because we can also read in the final judgment, or in the final summary of facts, that so 1 month later the recipient reported the meme, but then after he knew that the student was expelled, he also said, oh well, I think this is very harsh, and I never for an instant actually thought that this would be a death threat. So he kind of went back on his steps. So it's a really fascinating and of course in a very serious way, with very serious consequences for the sender of the meme. There's a lot of nuance and backstories to that case that would be interesting from a humor studies perspective as well. I just wanted to mention this. Yeah.
Yeah, if I can just follow up on that a little bit, it seems to me that, this is so fascinating and interesting because it's also impossible at the same time, because we're getting to a question of authenticity. And, a synonym for the digital age is sort of post-authentic, right? The era of post-authenticity. So what someone really means or really feels or really says is a question that is going to be changing with the context that you gave towards the start of your talk. So can you see any way of kind of at least narrowing down this sort of impossible scope that we are presented with?
You mean, sorry, just to make sure that I understood correctly, the scope that judges have to deal with in this type of cases? Did I understand correctly? Or
yes, and especially that it can change from time to time. So when the recipient of the memes reports the meme a month later, which should have been a clue that he really was not offended at the time, and then says, oh, actually, I didn't mean that, right? I wasn't offended. It's like, swatting that happens when people make calls to the police to report that there is, a child being held hostage during a Twitch streamer's kind of live streaming, and then part of that is if you can see the police, invade the house. Like, there's no authenticity there, but at the same time there is, right? Because that's where humor is entering into the equation, and people are finding that funny.
Yeah, no, exactly. That's really an excellent question, and it absolutely goes to the core of the matter. And I don't think it's ever going to be an exact science, clearly, and there will always be elements of uncertainty in the ways in which the court may approach a given contested joke. The only thing that we can hope for, perhaps, from this nascent dialogue between humor studies and the law or this hopefully increasing dialogue between humor studies and the law is that more consistent guidelines are built, and at least a consistent terminology and approach to these type of interpretive problems, in the awareness that there will always be an element of arbitrariness, and it's impossible to prevent these type of scenarios that you mentioned from happening. There's many other comparable cases where also courts are dealing with the same problem. The fleetingness, and also the ability for the interpretation of a given joke to change quite drastically over time, even on the part of the same recipient or audience. So the best thing one can hope for is, I would say, just a more consistent approach, because what we see right now is, even when we compare cases that are structurally quite similar to each other, as is perhaps the case of the two terrorist-themed jokes that I discussed, there is really a lack of a cohesive or coherent approach on the part of courts of law. So I think that could be the level of, let's say, consistency that we can aim for, while at the same time remaining aware that it's never going to be entirely predictable. Yeah. Thank you.
What Alberto is saying, get a humour person on the High Court. That's right. What I'm hearing from now.
I think we should lobby for
Right.
that. Yeah.
Right. Any more questions?
Thanks,
I
Jessica,
think
in the
that
meantime,
might
for
be
posting the
it.
link. Yeah. Yeah.
Yeah, thanks so much. I think that might be it for Alberto. Thank you so much for joining us, getting up so early, and please again give it up for Alberto and collapse
Thank
virtually
you,
in person if
really.
you can.
Thanks everyone for being
Thanks so much.
here, and I really enjoyed the discussion, and I'm very sorry that we are not meeting in person, but I hope there will be other opportunities in the future. Yeah.
Next time, I'm sure. We're having now another 2 panels come up, so we've got a 30-minute break, and then we continue with the third session and second session. Sorry for that. At 7. See you then, and thanks, Alberto. Have a good one.
Thank you, Ben. Thanks, everybody. Bye-bye.